Welcome to California Bar Prep, your study companion for the California Bar Exam. In this lesson, Professional Responsibility Overview. Let's begin. Professional responsibility is almost always tested on the California Bar Exam and is often tested alongside another subject. The safest approach is to analyze both California and ABA rules when they differ. California law includes the California Rules of Professional Conduct, the State Bar Act in the Business and Professions Code, Evidence Code Privilege Rules, and case law. The ABA model rules are not binding in California, but exam prompts often ask for ABA comparisons or reward noting major differences. The core themes are loyalty, confidentiality, competence, communication, fees, duties to courts and third persons, and lawyer discipline. On essays, identify every relationship: current client, former client, prospective client, organization client, court, opposing party, and unrepresented person. Each relationship triggers different duties. Competence. California Rule of Professional Conduct 1.1 requires a lawyer not intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. Competence includes learning and skill, mental, emotional, and physical ability, and diligence reasonably necessary for the representation. A lawyer may become competent by reasonable preparation or associating with a competent lawyer. Confidentiality. California Business and Professions Code Section 6068, E1, requires an attorney to maintain inviolate the confidence and preserve at every peril to the attorney the secrets of the client. California permits, but does not require, disclosure to prevent a criminal act likely to result in death or substantial bodily harm, after reasonable efforts to dissuade the client and, if reasonable, informing the client of the lawyer's ability to disclose. ABA Model Rule 1.6 has broader permissive exceptions, including some financial harm exceptions. Loyalty and conflicts. A lawyer must avoid representing clients with conflicting interests unless the lawyer obtains required informed written consent and reasonably believes competent, diligent representation is possible. California often requires written disclosure or informed written consent, depending on the conflict. Fees. Fees must not be unconscionable in California. Under the ABA, fees must be reasonable. Fee agreements should be communicated clearly. California requires written fee contracts in many matters where fees are expected to exceed statutory thresholds, subject to exceptions. Current client conflict. Identify whether representation of one client is directly adverse to another current client or creates a significant risk the lawyer's duties will be materially limited. Determine whether the conflict is consentable. Obtain informed written consent under California rules where required. Maintain confidentiality and competence despite consent. If conflict is non-consentable, decline or withdraw. Former client conflict. A lawyer may not represent a new client against a former client in the same or a substantially related matter without informed written consent. The substantial relationship test asks whether confidential information material to the new matter would normally have been imparted. If substantially related, possession of confidential information is often presumed. Duties to court. A lawyer must not knowingly make false statements of fact or law to a tribunal. A lawyer must not offer evidence the lawyer knows is false. A lawyer must correct certain false statements and may need to take remedial measures. California also imposes statutory duties not to mislead judges or judicial officers by false statements of fact or law. Duties to opposing parties and third persons. Do not communicate about the subject of representation with a represented person without consent or legal authorization. Do not use means that have no substantial purpose other than delay, embarrassment, or burden. Do not imply disinterest when dealing with unrepresented persons. Confidentiality versus attorney-client privilege. Confidentiality is an ethical duty covering information relating to the representation, including secrets from any source. Attorney-client privilege is an evidentiary doctrine protecting confidential communications between attorney and client for legal advice. Privilege has exceptions and can be waived. Confidentiality is broader. California versus ABA on disclosure. California is stricter. California's main permissive disclosure exception concerns preventing a criminal act likely to cause death or substantial bodily harm. The ABA permits disclosure in additional circumstances, such as preventing or rectifying certain client financial crimes using the lawyer services. On California essays, state both if relevant. Withdrawal. Mandatory withdrawal is required when representation will result in violation of law or ethics, the lawyer's condition materially impairs representation, or the lawyer is discharged. Permissive withdrawal may be allowed for client misconduct, unreasonable financial burden, or other good cause, but a lawyer in litigation may need court permission. Do not reveal client fraud too quickly under California law. Analyze confidentiality, exceptions, persuasion, withdrawal, and no assistance duties. Do not confuse informed written consent with mere disclosure. Consent requires the client's written agreement after adequate explanation. Do not represent both sides of a negotiation or transaction unless the conflict is consentable and all required consents are obtained. Do not forget duties to prospective clients. Even without retention, a lawyer may owe confidentiality and conflict duties based on consultation. Do not let a client control false evidence. The lawyer may not knowingly present perjury or fabricated evidence. Do not ignore California's unconscionable fee standard and written fee agreement requirements. A common essay presents a lawyer who takes a case outside her expertise, enters a questionable fee agreement, learns the client may lie or harm someone, talks to a represented person, and has a personal or business conflict. Discuss each duty separately. Professional responsibility answers are not won by one grand conclusion. They are won by spotting many duties. Use headings by duty: competence, diligence, communication, confidentiality, conflict, fees, candor, fairness, withdrawal, discipline. For each, state California law first. If ABA differs, add a short comparison. For example, if the client plans a financial fraud, California generally does not permit disclosure merely to prevent financial harm unless another exception applies, while ABA may permit disclosure if the lawyer's services are involved and substantial financial injury is likely. Always identify remedies and consequences: discipline, disqualification, fee forfeiture, malpractice exposure, sanctions, withdrawal, or reporting. California bar examiners expect practical ethics judgment, not just rule recitation. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.